The confession is the most powerful evidence in a court of law.
On this episode of Tunnel Vision.
And those of us who work in this field have seen that confession evidence will even trump DNA evidence. For whatever reason, police lock in on a suspect. They believe that suspect is guilty. Tunnel vision takes over, and nothing the suspect can say is going to shake them from that belief. The law gives judges way too much discretion deciding whether or not this was a coerced confession or a voluntary confession.
Welcome to part 2 of our interrogation episode. Joining me today is a special guest expert to analyze the details of Casey's interrogation and how it impacted his case.
Hi, Avery. How are you?
Good, how are you?
Good.
So much for meeting with me. I really appreciate it.
No, it's a pleasure. So where are you at in terms of...
Professor Steven Drizin is a criminal defense attorney, a professor at Northwestern University Law School, co-founder of the Center on Wrongful Convictions of Youth, and an expert on false confessions. Fans of the Netflix series Making a Murderer will recognize him along with his colleague Laura Nyrider as the legal defense team for Brendan Dassey. How did you get started in this specialization of law?
When I graduated law school, I went to a law firm and was unfulfilled. And then I got a job at my alma mater, Northwestern Law School, representing young people charged with very serious crimes. And very early on in my career at Northwestern, I encountered my first false confession. It was a confession from a 10-year-old boy to murdering his 83-year-old neighbor. I didn't know from false confessions. I didn't understand how someone could be pressured to confess to something so horrible. So I went around and I started talking to all of the experts in the field. And there were only a handful at the time. There was Richard Leo and Richard Offshee and Saul Casson. They basically gave me an education to help me understand what happened in my client's case. And after that case was resolved favorably for my client, Richard and I wrote an article that documented 125 of these cases around the country. And so I was off and running. It's near and dear to my heart, trying to prevent this from happening to anybody else.
Noticing the similarities between Casey's interrogation and Brendan Dassey's, I asked Professor Drizin why he thought that the judge in Brendan's case ruled that his videotaped confession was admissible in trial.
I think that there is this myth that somebody who is questioned like Brendan is coerced and therefore his confession should be suppressed. When in reality, most judges, even in cases of much worse coercion than Brendan experienced, let these confessions in. Part of it has to do with the fact that judges are elected, and tossing out a confession means essentially tanking the state's case in a high-profile murder. And sadly, many judges don't have the courage to do the right thing in these cases. I wasn't surprised that Brendan's confession was admitted. That was the main issue we challenged on appeal. We won in the federal courts twice, and then we ultimately lost by one vote. And it was heartbreaking because the whole case was built around sort of everything I built my career on, the unique vulnerability of young people to high-powered and pressure-filled interrogation tactics. If you polled the 20 million people who saw Making a Murderer in the first month, I think they left that documentary, and certainly they left after part 2, thinking, how could this confession ever have been allowed to be used to convict this young man when it happens all the time? So Brendan's case has been sort of a springboard for me to try to make sure it doesn't happen to anybody else and to pursue reforms that hopefully will prevent that from happening.
In the video and transcripts that you saw, what deceptive police tactics did you notice the police were using against Casey?
The central deception in his case is built around the lie detector. Casey believes that this lie detector is going to clear him. I'm going to pass with flying colors, he says. Hook me up. And the detective does what he usually does, which is to portray the machine as an impartial, unbiased observer that is 100% reliable at distinguishing the true perpetrator from people who are innocent. And I think Casey buys into that a little bit. And so when he's told that he failed, that is the sort of first step to breaking him down to a place of hopelessness where it becomes easier to manipulate him into confessing. So the polygraph is key. I don't know whether he passed the polygraph or whether he failed the polygraph. It really doesn't matter because the polygraph cannot accurately tell whether someone is telling the truth or someone is lying. It measures a person's stress and anxiety, not whether they're true, their statements are true or false. But people who are hooked up to that machine don't understand that. So that's the sort of first big ploy that is used. There are other deceptions used, references to the fact that our whole investigation demonstrates that it was you. Other evidence indicates that you were in that house, but it's the polygraph that is the central deception that sends everything spiraling downhill for him. And he pushes back. I mean, I'm impressed. He pushes back. He claims the machine wasn't telling the truth. He continues to assert his innocence dozens of times. But essentially, over time, the interrogation process wears him down and gets him to not confess to killing her, but confess to being in the home and seeing her body.
I then ask what mistakes the officers made during Casey's interrogation.
There are three errors we see in every false confession. The first error is called the misclassification error. For whatever reason, police lock in on a suspect. They believe that suspect is guilty. Tunnel vision takes over, and nothing the suspect can say is going to shake them from that belief. Casey was the boyfriend of Andrea, and he's within the group of people that are persons of interest. That doesn't mean he's guilty. That doesn't really mean he's a suspect. But the police focused him in on a suspect, and they misclassified him as guilty when he was innocent. And despite a whole bunch of evidence that should have said to them, look, we got the wrong guy here, they just pestered him until he gave a confession. Misclassification. The second error is coercion. And there is a ton of coercion in this interrogation. There's deception. There's accusation. There's isolation. There are promises of leniency and threats of harm. There's a suggestion to him that this crime was an accident and that people who commit accidents are good people and they're not likely to be punished as harshly as people who are cold-blooded and remorseless people. And those people are going to get a different recommendation to the prosecutor from this detective. And so there is coercion all over this interrogation. And the final error is contamination, right? Contamination is this. When somebody is guilty, they should be able to give you a complete and full narrative that matches the evidence at the crime scene, and that in the best of circumstances will lead police to evidence that they didn't already know about, right? There was property taken from this home. He couldn't lead them to any property. He couldn't tell them how she died. He couldn't lead them to any evidence that they didn't already know about. And when he tried to describe what he supposedly saw, he got all of those facts wrong. Anybody looking at this crime scene would immediately recognize that this was not a suicide. And the whole theory to get him to confess was to give him an alternative that made it look like an accident or made it look like a suicide. And over time, after being told no, 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 no enough times, his will was broken. So there's rampant contamination in this case, and there's extensive coercion. And it's mind-boggling that this confession wasn't tossed out by a judge before it went to trial.
I asked Professor Drizin to speak to the distinction of voluntary confessions versus credible ones.
So the first opportunity for any defendant to challenge his confession is through what's called a motion to suppress and to argue one of two things. One, there were Miranda violations. The suspect either wasn't read his Miranda warnings, or he didn't understand his Miranda warnings, or that his giving up of his Miranda rights was not voluntary or knowing or intelligent. None of the Miranda stuff applies to Casey. He understood his Miranda warnings. He gave them up, as do almost everybody who is innocent. What do I have to worry about? I have nothing to hide. So he gave up his Miranda rights. The next question is whether the confession is voluntary or involuntary. And this is really where the law makes the biggest mistakes, right? They view the fact that he waived his Miranda rights as significant evidence that his confession was a voluntary, not an involuntary confession. But really, Miranda rights have very little to do with whether the confession is voluntary. What you're looking at are the tactics that police officers use and the individual vulnerabilities that the suspect has to determine whether or not the police officers overcame his will. And if you look at this interrogation, this was an involuntary confession. We got a 19-year-old kid, never been in trouble with the law before, who is sleep deprived, who is grieving. There's trauma involved in learning that your girlfriend, the love of your life, has been killed. And he is exposed to deception, promises of leniency, threats of harm, accusations of guilt, all of the kinds of tactics that we know overbear a suspect's will. And unfortunately, as I said before, the law gives judges way too much discretion in terms of deciding whether or not this was a coerced confession or a voluntary confession. And they often get it wrong for the wrong reasons. The voluntariness question is different from the reliability question. And reliability really goes to the question of whether or not the confession itself fits the objectively knowable facts of the crime, right? This poor girl was tied up and shot at close range. None of that is in Casey's confession. There's no suggestion that there was a shooting. This was not a suicide. This was a murder. Whether it was a murder for robbery or not, I don't know. Whether they tied her up and they killed her because she could identify them as witnesses, or whether they tortured her or pressured her to give up her PIN number, I don't know. It could have been any one of those things, but this wasn't an accident and it wasn't a suicide. And so his statement that it may have been a suicide is just doesn't fit the evidence. And the other thing is that, okay, their theory of the case doesn't make sense. Casey couldn't drive a stick shift. There was a real problem with Andrea's car in that it leaked braking fluid to anybody who was driving that car, and there was no braking fluid anywhere on Casey's clothing. There were other problems, right? There was no DNA of Casey's on any of the items that were used to secure the victim, to tie her up. There was DNA on cigarette butts that didn't match his. From a reliability standpoint, this confession is unreliable. Now, not all of those facts were available for Casey at his original trial, but since his trial and since this evidence has come to light, the prosecutors, if they care anything about justice in this case, if they are following their highest duty, which is to pursue justice and not to keep convictions intact that are unjust, they would drop these charges against him and move on. So far, they're unwilling to do that.
And then something else that I picked up on was that he was very cooperative. He signed consent forms to search his house, his vehicle, gave hair samples, mouth swabs, gave up his clothing that he was wearing on that night.
Agreed to do a polygraph.
Of course, the polygraph. So how much weight does that carry in the assumption that he's innocent?
It should carry some weight to the jury and to the prosecutors and to the police officers. Someone who agrees to a polygraph and has nothing to hide, those are the actions of someone who is likely innocent. It's not rock solid evidence of innocence, but it's consistent with this young man's character, right? Why on earth would he want to brutally murder the woman that he loved? And this idea that, maybe she broke up with him and that caused him to snap is just ludicrous. There's no evidence of that being the case. None. Or that he was even capable of doing something like that. By all accounts, they had a very healthy relationship. It's just absurd.
Do you think jurors are equipped to judge the reliability of someone's confession?
Confession is the most powerful evidence in a court of law. And those of us who work in this field have seen that confession evidence will even trump DNA evidence, that jurors just have an impossible time understanding why anyone would confess to a crime they didn't commit, let alone a murder, which could land someone on death row in some states or behind bars for the rest of their life. And the reason is they can't imagine that they themselves would ever confess to such a crime. So it's a huge hurdle for defendants and defense attorneys to get over. Frankly, I think podcasts like yours, documentaries like Making a Murderer, telling people these stories over and over again in the public spaces can help jurors understand that people do falsely confess, and they do falsely confess to murders. But in the course of a trial, I think what's important is to have an expert like Richard Leo take the stand and have him explain the psychological processes that lead innocent people to falsely confess. If the state wants to hire another expert, fine, let's have a battle of the experts. But the basic fact that there are hundreds of examples of people falsely confessing to crimes they didn't commit is important to get before a jury. Will it make a difference? I don't know whether it will, but at least it gives the defendant a fighting chance.
In Casey's trial, one of the detectives leaked to the press that Casey had failed his polygraph prior to the trial. So how do you think that might have taken his presumption of innocence away before even going into court?
I read that too. And to me, that's like a fireable offense, right? Detectives, prosecutors, they know that polygraphs are inadmissible in evidence, and that's evidence that would never be before a jury. And so for him to leak that information and to say that he failed a polygraph without putting that into any context poisons the jury pool. Now, I don't know whether any of those jurors had heard about that fact that he failed a polygraph test. I don't know whether they were questioned about that during voir dire or not, but that is just grossly unfair and unprofessional. If any of those jurors had heard that, there's no way he could have gotten a fair trial. Now, was he tried in Lapeer County?
He was.
Okay. So at a minimum, I think those kinds of leaks should have enabled him to get the trial moved out of Lapeer County somewhere else. For whatever reason, that didn't happen.
The psychology behind a person who presumably understands their Miranda rights, understands that they can stay silent, understands that they can request counsel. How do they get from the point of strongly asserting their innocence to totally breaking down and just saying, I'll tell you what you want to hear?
It's relentless. Interrogation is a relentless process designed to make the suspect think that his assertions of innocence are futile. Okay, there's nothing he can say that can convince these detectives of his innocence. And then police officers begin to provide him outs, things that will be face-saving reasons for why he might have committed the crime, as opposed to him being a sick, twisted monster of a human being. And faced with those two alternatives, and only those two alternatives, suspects will often pick the lesser of two evils. How do they get there? They get there because they just give up. They're overwhelmed by the process. They just want it to end. And many suspects, and I suspect this is what happened with Casey, is that he was so confident in his innocence that he figured, okay, I got to get out of this room. This is overwhelming. They're not going to listen to me. Once I get out of this room, everyone will realize this is just a big mistake. And there's no way they're going to prosecute me for her murder. Unfortunately, that's not what happens in these cases. The confession becomes the truth. And it's almost impossible to shake police and prosecutors and juries of the notion that this confession is true and might be false.
And then in Casey's case, do you think part of it could have been immaturity and just like a lack of understanding that this confession can carry so much weight in a court of law? Do you think his youth?
I think his youth made a huge difference here. Youth inexperience with the criminal justice system. I mean, I don't know what his general feelings towards police officers were, but most people who grow up in a community like he grew up, they're taught to trust law enforcement officers. So it's much easier to break down young people into falsely confessing, frankly, because their brains are not yet fully developed. They make their decisions from a part of the brain that deals with flight or fear. It's not as rational and deliberate a part of the brain as adults use when they make decisions. And the midbrain, if you will, overwhelms the frontal lobe part of the brain, the executive decision-making part of the brain. And interrogations are targeted specifically to make suspects make emotional decisions, not rational decisions. And 19-year-olds, they're still learning how to make rational decisions. That's why you can rarely go a semester without seeing some 19-year-old drinking himself into oblivion, right? They make bad decisions, and police officers know that, and they target their inability to make good decisions in the interrogation.
I asked Professor Drizin to comment on the power dynamics that exist between a young suspect and an older, seasoned police officer.
There's always going to be a power imbalance. And I don't know whether or not these officers were armed in the interrogation room. But if you look at the interrogation, I mean, he is basically pinned against a wall. And the polygrapher and the other detectives are right up in his face, leaning in, invading his space. The design of the room itself reinforces that power dynamic. In other words, for him to get up and leave, even if he were to try to get up and leave, he's going to have to go through that investigator to get to the door. That power dynamic is there by virtue of the fact that this is a detective. It's there by virtue of the fact that young people are deferential to older people, especially people in law enforcement. And the only way to minimize that power dynamic is to have someone in that interrogation room who can act as an advocate for the young person. Now, we used to think that the best person to do that would be a parent, but sadly, parents are very easily manipulated by law enforcement officers into pressuring their kids to cooperate. They have the same deference to authority in many instances that young people do. And so I can't tell you how many times, and it's heartbreaking, I've seen parents essentially sell their children down the river by urging them to cooperate or even becoming an agent of the police officers. The only way to protect young people and to level the playing field is to have an attorney in that room. Simply telling them that they have a right to attorney is not enough. They don't really understand what that attorney can do for them. And again, for an innocent person who has nothing to hide, why does he need an attorney? Casey made that mistake in this case. He waived his Miranda rights, and it turned out to be a devastating mistake.
There's a little part in the video where Lieutenant Dwyer stands up and Casey kind of shifts in his seat. He's about to stand up as well. And Dwyer barks at him, "Stay where you are." And Casey immediately complies. Just because a suspect is given their rights doesn't mean that they interpret it the same way as it's meant to come across. So even though he was told in the beginning, you can leave at any time, you can request counsel.
Well, I think he tested it. I think at that point in time, he tested it. He'd had enough. He was getting nowhere with this detective, and he got up and he wanted to leave. And he was essentially told, "Sit back down. We're not done here." And to me, that is another powerful piece of the coercion here. It's essentially telling Casey, your rights don't make a difference here. You don't have the right to leave. You can't end this at any time. It's an extremely powerful piece of the interrogation, which is often overlooked, and you're very perceptive for picking that up.
On a broader level, I've read about how police consulting firms, state legislators are trying to move away from deceptive and accusatory tactics. A couple of years ago, even the Reed organization issued a statement saying, "We don't condone these deceptive tactics." So can you speak to any of the changes that are being made?
Yes, I can speak to those changes. I have been a partner with Laura and others to try to push those changes and to even draft some of these statutes to prevent the use of deception. Right now, it's to prevent the use of deception in interrogating youth. But the definition of youth these days, because of the adolescent brain science, probably should be extended to at least 21. I think that would be a powerful disincentive for law enforcement officers to use deception. If there's a risk that the confession might not come into evidence because you lied to a kid, they might not use it. They might use different methods that are less coercive. And I think that is really an essential protection that is needed. So, yeah, I'm very supportive of that. I think it's really important. Is it enough? No, it's not enough. It will reduce some of the coercion inherent in the interrogation process, but you're still going to see false confessions, even if you ban deception, because the process is overwhelmingly stressful for people. Over time, even you or me or my children who I've lectured repeatedly about this problem can be made to falsely confess. And our innocence is a risk factor for false confessions because we think, okay, I'll tell them what they want to hear. I've got to bring this to an end. And then once we're out of this room, everyone will realize that this was all a lie. And Casey's recantation, immediate recantation during that phone call to his mother says it all. I told them what they wanted to hear.
Does this deprive immature 18, 19, 20-year-olds? Do they kind of fall through the cracks because of the way that cutoff is set?
I think that they do, but I think that my experience has been that change in this country, especially change in criminal justice, is incremental. And that you start with young people, then you move to emerging adults because of the brain science and because of people like Casey will fall through the cracks. And then over time, deception becomes disfavored for everybody. It's an arbitrary cutoff, and we realize that, but the message of it's just not right for police officers to lie to kids is a message that is easier to sell right now than it's not right to lie to older teens. Deception is always going to be something that a court looks at. But these laws basically says to them, you have to look harder when you have a police officer lying to a child. And hopefully it'll get to the place where they say, we're going to take a good hard look at this for 18, 19, 20, and 21-year-olds too. I am just hopeful that these law enforcement officers will wake up and smell the coffee here, because they're destroying lives.
Coming up on Tunnel Vision.
It appeared that somebody she knew, they had a drink because this other glass in the sink had another woman's DNA on it.
Listen to me very carefully. You need to look at that and tell them, I am not talking to you anymore. I am requesting legal counsel, and my legal counsel will be here first thing in the morning.
And if I had to make up a suspect list to really investigate, I guarantee I could give you 5 or 6 people.
You've been listening to Tunnel Vision Episode 4, Interrogation. If you have any information that could help with the investigation of this case, contact us directly at tunnelvisionseries@gmail.com. Tunnel Vision is written, produced, and hosted by Avery Tatro. Editing by Michael Tatro. To keep up with new episodes, subscribe to Tunnel Vision on Apple Podcasts. Original music is by Michael Tatro and Suno AI.